first case we will be hearing today is State of Ohio versus Lewis McIntyre. Jacqueline Corrigan for the State of Ohio, Attorney Stephen Hanudel for Mr. McIntyre. You will each have 15 minutes to present your case. Please stand behind the podium. This is being recorded. And Mr. Hanudel, you may reserve up to 5 minutes for rebuttal. Please let me know how much time you would like to reserve because I will be keeping track of the time. And with that, we have read your briefs and we are ready to proceed when you are. Mr. Hanudel, would you like to reserve some time?
Yes, 5 minutes, please. Thank you, and may it please the board, I'm Stephen Hanudel, I represent the appellant Lewis McIntyre Jr. This concerns this 2009 case. I'm sure you all are familiar with the 91 case that we've been fighting, but this occurred when he was on a parole in the 91 case, and so the reason why we're still fighting this is because of the effect on the parole in the 91 case, even though he has served time on this case. But this case has some interesting parallels because, like in the 91 case, when the Ohio Supreme Court found there was no final appealable order because not all the charges were disposed, this case has the same issue with different facts, but the same issue. And we brought that up in 2014, in which Judge McCarty at the trial court level made an honest effort to correct the problem, and she recognized the mistake she made. There were 2 obstruction of justice counts in which she dismissed one under Rule 29 and meant to send the other one to the jury, but she sent the dismissed one to the jury, and the one that she had not dismissed never went to the jury. And so, and we got that all straightened out in 2014, but then this court, I know none of you were on the panel on the prior decision, and I think, based on the Ohio Supreme Court case law that's come out since, I think this court was mistaken in its decision in the case that came out in January 2016, because that was right after the Ohio Supreme Court had issued a mandamus in the 1991 case, finding there was not a full disposal of all the charges in that case. And I had asked the court to consider that authority, and even though the mandamus case was a plurality decision, and the court noted in a footnote, and they recognized that there potentially could present a finality issue under the circumstances involved in this case. So this court was not oblivious to the facts that there was a finality issue. And then
counsel, in that 2016 case, in the footnote, the court unanimously said we're not going to follow that precedent, not precedent, that it's really not precedent because the plurality opinion doesn't bind the court.
Correct, but that gets to my next point. Because State v. Craig came out in 2020 from the Ohio Supreme Court, and that was a unanimous Ohio Supreme Court decision, 7-0, on the issue of final appealable orders in criminal cases. They cited the mandamus case as support for their decision, and so...
But counsel, even though Craig didn't come out until 2020, wasn't the 9th District already following Craig in the 1990s? Weren't we already saying that finality didn't happen unless all of the charges were disposed of?
There were cases all around the state regarding the finality issue, and it finally all tied together in Craig as far as on the Supreme Court level, where the Supreme Court said they just settled it once and for all. However, I believe this court sort of differed from the other appellate courts because this court had filed State v. Saxon, which was another Ohio Supreme Court case, I believe in 2006, that left open the possibility where maybe you could sentence on the charges individually, or the individual charges could be appealed individually. It's sort of maybe left open that interpretation, and the Ohio Supreme Court finally said in Craig, no, that's not the case. In order for a criminal defendant to have a right to an appeal in a criminal case, all charges must be disposed, whether they're dismissed or they're sentenced. And so,
well, counsel, I was just going to say, whether it's good or bad, I've been here for 24 years, so I've been there when it was this way in the law, every which way.
Right.
And I think, as I always say, our court started this fiasco with the final bill order and with all the, through Baker and 32, all those things many, many years ago. So I understand what you're saying about the Craig case, but I also would second Judge Hensel's question because I know I wrote a couple dissents where I thought you should be able to appeal immediately whenever somebody is sentenced, whether there's another count or not, because as I said in my dissents, it's not fair to the defendant to sit in prison and have to, wait in order to get an appeal whenever he's already been sentenced.
Well, and I understand that your point of view, but ultimately the Ohio Supreme Court did settle that issue with Craig, and Craig came out while this matter has still been in its direct proceedings, because Mr. McIntyre appealed the 2009 sentencing entry that got affirmed, and then he reopened that appeal. It got reversed, I believe, twice for sentencing issues, which still permeate today. There's allied defense issues that are laid out in my brief that still weren't taken care of by the trial court judge. But then there was a 2016 appeal. So this is still, this appeal is still a descendant from all that action. That this is not a result of any collateral attacks like a post-conviction petition or anything like that. So since Craig came out with all this pending, it applies.
But how does Craig invalidate the law of the case doctrine? I mean, if that's your argument, and I might be mistaken, that you're arguing that State v. Craig invalidates the law of the case. Yes or no?
I think in this case it would, given the facts and given the basis to which this court had decided the prior appeal and regarding the finality issue, and given that we still have been contesting that and that the proceedings have not yet closed, if you will, we've been, like I said, this appeal is a descendant from the last one, and with Craig coming out in that, I believe I cited case law that, that the law of the case changes at that point. When new authority comes out in the middle of the fight, of the litigation, then that changes the course of how the law is going to get applied going forward. So
I guess I would say with Craig, again, to dovetail Judge Hensel's question, Craig was different because even though they cited and said ordinarily this is not a final appellable order and cited, I would propose that maybe they were just citing the McIntyre case for just the general law in that area. But the point is with Craig, they made an exception and said, well, it's severed here, and and there is a final appellable order that they can appeal.
And I think Craig dealt with a factual situation, I believe, involving competence of the defendant.
Right.
And then that's not the case here.
No, I know, but that's the whole point, isn't it? The facts are a lot different, and maybe you're trying to say all this new law of the case, or it dispenses with law of the case, but it's really not even factually even close to what we have here.
But before Craig got to the exception of dealing with the competence or incompetence of the defendant in that case, they first dealt with the law of Ohio Revised Code Section 2505.02. They first laid that out and laid it out how this is how it's supposed to work for everybody. And once they solidified that point, then they moved on to how it applied to the facts of Craig in the competence of the defendant. So in the first half of that opinion, about 2505.02 and how that interplayed with Criminal Rule 32C, the Ohio Supreme Court cogently laid that out. They cited the McIntyre mandamus case, but they also cited other cases too. That wasn't the only one. They cited other appellate law cases as well. So, and they ultimately decided and I think if I'm recalling the wording of the decision correctly, that it's about the text of the statute. Whether the action had been determined, and the Ohio Supreme Court interpreted that to mean, in criminal case, all charges had to be disposed. So, and they firmly lay that out. They discuss the Saxon case as well, and so I think they laid to rest any possible interpretations from Saxon, and then they moved on to how it applied to the competence of the defendant in that case. So, we don't have a competence issue in this case, so we can simply look at the first half of that decision as to applies to 250502, the action being determined, and so on and so forth. And given that these proceedings, the trail of these proceedings still go all the way back to 2009, this court, Craig, I think, overrides this court's decision in 2016, and I think the issue is right for this court to recognize that the 2009 sentencing entry was not final. And that's ultimately what this first assignment of error is about, that the July 2009 entry was not final. There was still a pending charge, and that's where I talk about if you were to do a non-pro-tunc.
Counsel, I
Yeah.
need to interrupt, but I want to let you know that you're into your rebuttal time.
Okay, I'll just finish up my real quick point. If you were to do a non-pro-tunc of the July 2009 entry to reflect what actually took place in the courtroom, it would reflect that the judge had dismissed the obstruction of justice pertaining to bad checks, but sent that to the jury, but did not dismiss the obstruction of justice, I can't remember what the underlying one part of that was, the other obstruction of justice charge, and that was not sent to the jury and was not disposed. So if that, that in a non-pro-tunc could be done any time, if that entry would just get corrected on the base, that would, right then and there, it's not final. So I'll reserve the rest of my time.
Thank you, counsel. You'll have almost 4 minutes. You may proceed.
Thank you. I was just noticing that Judge Carr is still writing, so I won't give
Oh,
him
thank you.
time. Good morning, and may it please the court. I'm Jacqueline Corgan on behalf of the state of Ohio to urge this court to do something in this case. And the something is not necessarily what Mr. McIntyre wishes it would do, because this is the 6th time that this case has been up to this court to consider various aspects of Mr. McIntyre's 2009 conviction, and it probably will not be the last, because this court does need to remand this case back to the trial court, but not for the reason that Mr. McIntyre believes. There is actually, the state's position is that there is one thing that this court needs to do, and that is to remand back to the trial court for the sole and limited purpose of essentially reissuing a journal entry that the trial court issued in May of 2012. Now, Mr. McIntyre's arguments all hinge on his belief that this court is permitted to reverse itself once it is issued a decision and once the Ohio Supreme Court has declined jurisdiction to review it, which is what happened in what I have termed, and what I think this court would probably term McIntyre 5, which is the 2016 case. Now, this court has asked a lot of questions about the law of the case doctrine, and that, just very briefly, as the court is aware, that doctrine holds that an appellate decision resolves an issue in future cases in the trial and the appellate court, and that once the Ohio Supreme Court declines jurisdiction to review an appellate court case, that appellate court decision is the law of the case going forward, and it cannot be revisited by this court. Now, what Mr. McIntyre is arguing today is that State versus Craig is an intervening higher court decision that would break the chain of the law of the case. That is not correct for one key reason. State versus Craig is not an intervening decision, at least as far as this district, because what State versus Craig did was to essentially enshrine what has been the prevailing law of this district out of this court for years, as Judge Carr and Judge Hensel have asked. So Craig did not announce a new principle of law to this court. This court had been following the essence of Craig all along on its own. So an intervening decision that would break the chain of the law of the case doctrine has to be something that contradicts what the law was that this court had based its opinion on. And this court was relying on its existing precedent when it decided McIntyre 5, and in the process decided that the original July 2009 journal entry of Mr. McIntyre's sentence was a final appealable order. So because Craig is essentially announcing for the entire state the principles upon which this court has been operating for the last 15 years at least, does not operate as an intervening case to break the law of the case doctrine and to invalidate this court's holding in McIntyre 5 to allow this court to revisit its prior opinion. So with respect, that's a settled issue as to whether the July 2009 order was a final appealable order. Now, why we still needed to be remanded, however, was in the wake of McIntyre 5, this court sent the case back to the trial court to correct what it had done in the January 2015 Nunc-Pro-Tunc journal entry where the court granted a criminal 29 dismissal pursuant to Mr. McIntyre's motion to declare a mistrial on what was renumbered as count number 4. This court in McIntyre 5 found that was beyond what the trial court was empowered to do and sent it back. What the trial court then did in its June 4th, 2021 sentencing entry was it reinstated that count and stated that the jury had found him guilty of a first-degree misdemeanor, which is what this court had ordered the court to do, say that he was a misdemeanor, it was a misdemeanor offense rather than a felony. But then the court said that she was sentencing him to 6 months for a 5th-degree felony. That's inaccurate. What it should have been was found guilty of a first-degree misdemeanor, sentenced for a first-degree misdemeanor. Then Mr. McIntyre took the appeal in case number 30039, and subsequently the trial court then, about 9 months later in March of 2022, issued another Nunc-Pro-Tunc order, this time finding that renumbered count 4 was a 5th-degree felony, both that the jury convicted him of a 5th-degree felony and that the court was sentencing him to 6 months for that 5th-degree felony. Again, the correct announcement should have been renumbered count 4, was found guilty of a first-degree misdemeanor and sentenced for a first-degree misdemeanor. And that is where the state's position is that yes, this needs to go back to the trial court, but not to revisit his convictions, but only to correctly announce the level of offense for which the jury issued a guilty verdict, and to indicate that the sentence that's being imposed is for a first-degree misdemeanor. So, again, the closest approximation to a correct order would have been the May 2nd, 2012 journal entry from which Mr. McIntyre then appealed again. So, again, the state's position is that the 2009 sentencing entry was indeed a final appealable order, but other things have been resolved in this case as well over time. One of the points is that the trial court had subject matter jurisdiction and maintained subject matter jurisdiction over Mr. McIntyre's case. This court decided that in McIntyre 5, and there is no indication that there is any intervening case law or intervening case from the Ohio Supreme Court that would break the chain of the law of the case doctrine regarding that point. Also, it has been resolved by this court in McIntyre 1 and McIntyre 2 that the trial court had personal jurisdiction over Mr. McIntyre in this case. Again, there's no intervening case to break the chain of the law of the case doctrine regarding that point. Because there was subject matter jurisdiction and personal jurisdiction over Mr. McIntyre, that means that any error in the journal entry did not render it void, it rendered it voidable, which means that it could only be reversed by this court. It cannot be voided by the trial court. A fourth point that is settled law in this case now is that there was indeed sufficient evidence that supported Mr. McIntyre's conviction for renumbered count 3, which was the tampering with records that eventually merged with count 1. That was resolved by McIntyre 3. And one of the last points that was resolved by this court in McIntyre 5 was that no further merger of Mr. McIntyre's offenses is appropriate, and there is no intervening case law from the Ohio Supreme Court to contradict that ruling. So that is also settled law that cannot be revisited by the trial court or even this court, because again, McIntyre 5, the Ohio Supreme Court declined jurisdiction. So that's essentially the sum of the state's case, is that, again, all these points that I've just said, these are all settled issues. What still remains to be resolved is we still need a correct entry indicating the offense level for which Mr. McIntyre was found guilty in renumbered count 4, and the correct offense level for which the trial court imposes sentence.
When you say corrected entry, are you talking about a non-pro-tunc, or are you talking about an alcohol entry?
That's another question, unfortunately, because I understand that in 2012, that journal entry that I'm representing to the court is the closest approximation to a correct entry, even though, I will mention this, and this has been waived by the state, is that, you know, between the 2009 and the 2012, Mr. McIntyre's sentence on the first count, the tampering with evidence, went from 4 years to 3 years, and the state never appealed that diminishment of his sentence, and we're not going to quibble about that. I will mention it, but that's the closest approximation to a correct entry. Now, because that was remanded to the trial court by this court to consider again whether any of the other offenses might merge, I cannot really say, because I think I would have to do some more research, I can't really say that that is an entry that can be corrected with a non-pro-tunc. It may require going back and having a resentencing to accomplish the same thing. As painful as I know it would be for all parties, but that's the outcome that has to happen, is that in the state's view is that the substance of that entry has to be memorialized.
So are you saying that the court, by entering, I guess it's 2 orders now, saying that it was a felony instead of a misdemeanor, that makes it void?
No, I'm not saying it's void. It is a void. For instance, the 2021 sentencing entry where it was mistakenly saying it's sentencing on F5, that's a voidable entry, and that could be corrected by a non-pro-tunc. The problem is that when the non-pro-tunc came out, it made it worse. So potentially a non-pro-tunc of the 2021 sentencing entry could be issued to correct it all. So unless the court has any further questions, again, the state's position is this needs to go back for a corrected entry, however it's done either through resentencing or a non-pro-tunc, but the corrected entry has to be entered. And unless the court has further questions, the state will rest on its brief, and thank you very much.
Thank you, counsel. Any questions? Thank you, counsel.
Thank you.
Thank you. As far as the Ninth District, applying the finality, the issue on final appeal orders, in years past, I need to make that emphasize the point that as much as that it may have applied that issue to other defendants, it hasn't always applied that to Mr. McIntyre, and that's evident by how the court decided his 1991 case in 2018, when despite the Ohio Supreme Court finding that there was no final appeal order previously, and then one was issued, and then Mr. McIntyre filed a direct appeal, this court had said in that case that, well, this court went ahead and applied res judicata, even though the Ohio Supreme Court said not to, but the Saxon case was cited in that decision. That was in 2018, which is then 2 years before Craig comes out putting the Saxon interpretation to rest. So this court, as much as this court had recognized that charges have to be disposed in order to appeal, there was still that interpretation out there. Judge Carter had felt about the Saxon case applying to where where charges could be appealed individually, and so that was still out there, and that wasn't fully that difference in opinion, that difference in interpretation wasn't fully laid to rest by the top court until 2020. And so now that it has been, and in these appellate proceedings, back and forth in the 2009 case here, has still been going on, Craig does operate as an intervening case to break the law of case chain, and it does give this court a basis to reverse itself in its 2016 decision, and therefore, and then recognize that what the trial court judge did in 2014 to correct the mishap of the 2 obstruction of justice charges was correct, and that ultimately that this court just needs to recognize that the July 2009 entry was not final, but because this court had previously vacated the trial court judge's actions from 2014, this has to be remanded so that we go back for a new sentencing hearing on the 3 remaining charges: tampering with evidence, tampering with records, and theft. Because
I guess what I'm trying to figure out is, it sounds like you and the state both agree it has to be remanded. It's just for the reasons why.
right, the state has a different reason.
Yeah, oh, does it matter as long
Yeah.
as it's remanded?
It does.
And a new sentencing entry is entered?
It does matter because if the state wants this court to recognize that the July 2009 entry was final. We're asking this court to recognize that it was not final, and that therefore he still has not had a final appeal of order. The trial court judge did issue one in 2014, but that was vacated by this court. So now, that's as if that never happened. So from now 14 years later, from 2009 to now, there has been no final appeal of order that has been upheld. So so we have to go back to have a new sentencing on the 3 remaining charges. The obstruction of justice was dismissed on Rule 29, 2009. The state dismissed the other obstruction of justice charge in 2014 in open court. And so now you're down to 3 charges. He just has to be sentenced to those 3, and valid offenses have to be resolved, and there's it'd be time served. But also that as far as the effect and control proceedings, which I know is outside the purview of this court, that's something that we would have to take up separately as far as with the parole board and so on and so forth, because if he didn't have a first-time conviction until maybe in the future here.
Counsel, your time is up,
Okay.
so you just want to wrap
Okay.
up.
But it could affect, there's a lot of overrated effect, so it's very important that this court does recognize that the July 2009 entry was not final.
Any other questions? Thank you.
Thank you.
Thank you very much for your presentations. We will take them under advisement and issue an opinion in due course. We will mail that opinion to the parties. to you, and it will be posted on the Ohio Supreme Court website that day.